flagship event of the International Teaching Month of this institute, which we organize every year. Now, it is a session which is going to be happen on the comparative law. The title of the today's lecture is, that is, a constitutional borrowing and transplants in Bangladesh with a focus on the influence of Indian constitutional law. This session is going to be taken by Professor Dr. Muhammad Ekramul Haque. It is my pleasure to introduce Professor Haque before he is going to deliver his talk here. Professor Haque is a professor of constitutional law and comparative constitutional law at the Department of Law, University of Dhaka, of which he is also an alumnus. He earned a gold medal for his academic achievements at the university. He did his PhD in constitutional law and international law at Monash University in Melbourne, Australia. He is the coordinator of the clinical legal education program and an additional director of the IQAC in the Faculty of Law. He also acts as a resource person for the training of judges and government officials in Bangladesh. He has authored many books which has been published by reputed publishers. He has received many awards and scholarships, which includes Monash Law Dean's Awards, Monash International Postgraduate Research Scholarship, Monash Graduate Scholarship, and so many scholarships he has got. Now, he has delivered so many lectures as invited speakers in different universities at home and abroad. So now I welcome Professor Haque to deliver his talk. Before I hand over the mic to Professor Haque, I would request to all of you, please keep your camera on and your mic should be on mute mode. Thank you. Thank you, Professor Haque.
Well, thank you, Professor. Just a minute, sorry, Sam. Sorry. Well, good morning, everyone. At the very outset of my lecture, I'm highly appreciating this particular initiative of International Teaching Month taken by near my university, law faculty. And I'm sure that this is also one of the largest, perhaps, cross-cultural lecture series of the legal experts from around the world. And I'm truly honored being invited to this great program, and I'm grateful to near my university for their kind invitation to speak in the session on comparative constitutional law. Well, constitutional borrowing and transplants are two very interesting and popular terms of comparative constitutional law. There are lots of theoretical debates even regarding constitutional borrowing. There are also different methods of comparative constitutional law for constitutional borrowing and constitutional transplants. Some jurists even think that constitutional borrowing and transplants are not possible at all due to the fact that one particular constitutional provision, an idea, will not necessarily fit completely in another legal or cultural context. For example, Pierre Legren thinks that true transplantation is never possible because a system can never be transplanted, and at most, some linguistic words can be transformed from one jurisdiction to another. However, I'm not going through that debate. For the purpose of today's lecture, I'm considering constitutional borrowing and transplants as established concepts of comparative constitutional law, which I'll examine from Bangladesh perspective, and the lecture on constitutional borrowing and transplants in Bangladesh with a focus on the influence of Indian constitutional law will be divided in two parts. Firstly, I will examine the role played by comparative constitutional law in the adoption of the Constitution of Bangladesh. And I will show to what extent the Constitution of Bangladesh borrowed different constitutional ideas and models from global comparative constitutional law gene pool. Secondly, I will analyze major constitutional transplants of foreign ideas through constitutional judges in Bangladesh. In discussing both these parts of my lecture, I will shed light and focus on the influence of Indian constitutional law, both in constitutional borrowing and constitutional transplants. Well, generally speaking, if you ask me the question that what is your opinion regarding constitutional borrowing, I must say that constitutional borrowing is inevitable, and that is in the tone of Dr. D.D. Basu, a famous comparative constitutional lawyer in the world. He also said the same thing, that comparative constitutional law, constitutional borrowing is inevitable. And especially for the modern constitutions, which are latecomers on the board of global constitutional law gene pool, this particular borrowing is essential. For example, for a country like Bangladesh, which adopted its current constitution back in 1972. So it was adopted at a time when a set of constitutions were already developed in the world. But I'm not saying that constitutional borrowing is not essential for some oldest constitutional law jurisdictions. For example, if we talk about American constitutional law, constitutional borrowing is also important in a jurisdiction like American constitutional law. Why? Because of updating their constitutional law. So constitutional borrowing plays role in different ways. It plays role at the time of adoption of one particular constitution. It plays role continuously in the development of that particular constitutional law in that particular country. So the point that I was saying, that constitutional borrowing or transplants in modern age is something which is inevitable, though in different forms. And constitutions around the world actually enrich themselves through such constitutional borrowing and transplants. For example, if you talk about American concept of judicial review, I'm talking about Marbury versus Madison, one of the most popular constitutional law cases in the world. And that particular concept has actually been exported from the US, I think, to almost all constitutional jurisdictions in the world. And as such, for example, country like Bangladesh has been enriched by the judgment pronounced by American Chief Justice Marshall in Marbury versus Madison. Well, it is true that from an academic point of view, there are, of course, a number of associated problems which are linked with constitutional borrowing and true constitutional transplants. Nevertheless, considering these as a reality that cannot be denied, modern comparative constitutional lawyers are trying to make this borrowing more effective and beneficial by avoiding bad borrowing and bad transplants. I'm using the term bad borrowing because there are some constitutional borrowing which are not put in the good book of the comparative constitutional lawyers. One such evil aspect of constitutional borrowing is abusive constitutional borrowing, which concept has recently been developed and explained in details by Rosalind Dixon in the book on abusive constitutional borrowing published from Oxford University in the last year. Well, I generally agree with Rosalind Dixon about different types of abusive constitutional borrowing, which I will use in my lecture in explaining influence of comparative constitutional law in Bangladesh. I'm using the term abusive constitutional borrowing because this is the most recent observation about constitutional borrowing from the comparative constitutional lawyers around the world, that if you have to do constitutional borrowing, we must avoid doing abusive constitutional borrowing, because abusive constitutional borrowing is something which is extremely bad, that may take different forms in the tone of Rosalind Dixon. As I said already, that in terms of abusive constitutional borrowing, I'll be agreeing with Professor Rosalind Dixon's 4 different types of abusive constitutional borrowing. The first one is the sham borrowing, that a constitution is saying that, well, I'm adopting a catalog of rights, but in fact, none of those rights is being implemented in that particular constitutional law jurisdiction. But the people are knowing that, okay, we had a good constitution, we had the full catalog of human rights in our constitution incorporated, but in practice, that does not have any sort of implementation. That is known as sham borrowing. Another abusive borrowing is abusive selective borrowing. Selective borrowing means if you are taking one part of one big package. You are not taking the concept wholly from one jurisdiction. So you are taking one particular aspect of one particular legal constitutional package that only suits you, that you want to see in your own jurisdiction, and avoiding another part which you do not like. For example, what happened is such type of abusive selective borrowing that actually happened back in 1972 in Bangladesh. At the time of incorporating economic, social, and cultural rights in our constitution, we have referred to Soviet Union constitution that recognized those economic rights in the way that it will be the progressive responsibility of the state to implement. And Indian constitution has recognized these particular rights in the same way, I know. But the problem is that Soviet constitution did not declare that those constitutional principles are not judicially enforceable. But we did it in 1972. India did it in 1950. So whatever was done by Bangladesh in 1972 regarding judicial unenforceability of constitutional principles on economic, social, and cultural rights back in 1972, that was nothing but to some extent following the Indian model. But at the time of our adoption of our constitution, we referred to the constitution of Soviet Union, but we did not refer to the entirety of Soviet constitution. And that is called abusive selective borrowing. Another type of abusive borrowing is abusive acontextual borrowing, that I completely know that this particular foreign element will not bring the same result in my jurisdiction, knowing that I'm going to adopt one foreign idea and to transplant that foreign idea into my constitutional law jurisdiction with a bad motive, with an ill motive, knowing that it will not bring the same result. This is called abusive acontextual borrowing. Well, the last one, according to Rosalind Dixon, is antipurposive borrowing, that it will not serve the same purpose in that particular jurisdiction. Well, that's why Professor Mark Tushnet, one of the most famous comparative constitutional law world, he actually advocated for different theories like functionalism, expressivism, bricolage, and we know that there are different theoretical methodologies available for making constitutional borrowing. However, I'm not going through that particular debate of constitutional transplant and constitutional borrowing. Rather, I'll be focusing on what actually happened back in 1972 in Bangladesh, and in doing those constitutional borrowing, to what extent Indian models were followed by Bangladesh, and later during the last 50 years time, how the judiciary in Bangladesh has actually interpreted different constitutional law issues from comparative constitutional law perspective using Indian constitutional law as one of the tools of comparative constitutional law methods. Well, and I must share this particular information with all of you because it's a very big information for all of us in Bangladesh, that the constitution of the present constitution of Bangladesh is going to complete its 50 years on 16th of December of this particular year. It's a very big thing for a country like Bangladesh, small country like Bangladesh, to complete its 50 years of uninterrupted constitutionalism, and during the last 50 years, this constitution was not changed, was not abrogated. So we continued with this particular single constitution for last 50 years. Well, let us now show the influence of comparative constitutional law on the adoption of the Constitution of Bangladesh. And let me start with the preamble of the Constitution. Well, in the preamble of the Constitution of Bangladesh, we see that people was taken as the enacted authority, as the enacting authority, that who enacted the Constitution of Bangladesh. Generally speaking, this is a constitutional model, a popular constitutional model around the world to speak in the name of the people. And India did the same thing in the preamble. So the people of India are the enacting authority of the Indian Constitution. Just likewise, people of Bangladesh are the enacting authority of the Constitution of Bangladesh. Also, Casey Ware posed that question, that is not this unreal to speak about the people if there was no substantial participation of the people is found. The thing is that a referendum perhaps could rectify that problem of people's participation, but in our case, no such referendum was held in Bangladesh back in 1972. Well, there are several such examples of constitutional borrowing from India. For example, if you talk about the constitutional model of civil and political rights, which particular model in fact Bangladesh adopted back in 1972. Basically, it is true that it was an American model. It was an American model. Why? Because American Constitution in its First Amendment said that Congress shall make no law abridging different types of freedom of speech, press, assembly, petition, and other things. So that was mentioned in American Constitution from negative perspective, that the state is not going to breach any of those freedoms, or the Congress is not going to make any law violating those constitutional rights. Those particular civil and political rights were inserted in Bangladesh Constitution following that American model first, but then it deviated a little bit from American Constitution and made more in line with Indian model. And what is that Indian model of constitutional protection of civil and political rights? If you look at Indian Constitution, Article 19, that says about those particular constitutional freedoms, like freedom of speech and expression, assembly, association, to move freely throughout the territory, and so on. Well, the thing is that the Indian Constitution says that no law can be made violating those fundamental rights, of course. But at the same time, Indian Constitution has declared them to be the rights. It shows the idea that Indian Constitution has made those civil and political rights in its Constitution, both from negative perspective and positive perspective. Negatively speaking, a state cannot make any law violating those rights. Positively speaking, people do have the rights. So Constitution declared them to be the rights, unlike American Constitution. Because if you look at American Constitution, First Amendment, that has not declared them as rights. Rather, that said merely that the Congress will not make any law infringing those rights. Well, if we look at Bangladeshi Constitution, of course, those articles, for example, Article 36, 37, 38, 39, that deals with all those civil and political rights, are actually modeled in Indian model. Thus, we see that in adopting the constitutional model of incorporation of civil and political rights in the Constitution of Bangladesh, Bangladesh actually adopted a blend of both American and Indian models in its constitution. Well, secondly, I'll show that what was the influence of comparative constitutional law at the time of adopting our constitution back in 1972 in the Constituent Assembly. Because we know that according to the originalist theory, we need to sort out the meaning of any constitutional text by examining the debates that took place in the Constituent Assembly of one particular country. So the debate that took place in the Constituent Assembly of Bangladesh is immensely important to sort out the influence of comparative constitutional law in Bangladesh. Khandakar Abdul Hafiz, one of the members in the Constituent Assembly, he said in our Constituent Assembly that the preamble should contain some philosophy of the state. And as such, the preamble of the Constitution of Bangladesh contained certain philosophies, just like Indian Constitution as well, because the preamble to the Indian Constitution also contains a philosophy, that that's a secular state, that there's a democratic republic, something like that. Well, but interestingly, in the Constituent Assembly debate, the Constitution of India was not referred. Rather, the preamble of the American Constitution, French Constitution of 1958, Russian constitution and the constitution of Yugoslavia were referred to by the Constituent Assembly debate. Well, there may be one of the reasons behind frequent referral to Russian constitution, Yugoslavian constitution, Czechoslovakian constitution, German constitution. The reason perhaps is the influence of Russian bloc at the time of our liberation war, because we know that India, along with Russia, helped us in achieving our independence back in 1971. So there was a natural reflection of all those constitutions in the constitution that we have adopted later in 1972. Well, let me now focus on what happened in our Constituent Assembly at the time of accepting the constitutional model of insertion of the writ jurisdiction. We all know generally that it comes from the United Kingdom, the British constitutional law, but later it was developed a lot in Indian jurisdiction. But in 1972, we did not follow completely either Indian model or Pakistani model. That actually named different types of writs in the constitution. So if you look at the constitutions of India or Pakistan, both of those constitutions have actually mentioned the names of the writs that the Supreme Court can give remedies in the nature of habeas corpus, quo warranto, certiorari, mandamus, prohibition. But what happened in Bangladesh? We deliberately omitted the names of the writs. Why? Why you did not mention the names of the writs, those Latin terms in our constitution following the Indian model? India was referred to, but not to accept the names, rather took as contrario, not to follow. So why was not this followed? That was clarified by the chairman of the Constitution Drafting Committee, Dr. Kamal Hussain. He said that if we mention those Latin terms, then the jurisdiction will be narrower. And if you do not use the name, for example, if you do not use the name certiorari, then the court can exercise it from a broader horizon. For example, if we ask a question that against whom a writ of certiorari will lie, then we need to take into consideration what developments have already taken in the name of certiorari. But if we just incorporate in our constitution that this particular remedy will lie against any person performing any function in connection with the affairs of the Republic, that will open the horizon of certiorari. So we did not use those Latin terms in our constitution. Well, now let me come to a very interesting part of both Indian and Bangladeshi constitutions. A lot of debates were in the Constituent Assembly regarding this particular idea of incorporation of economic, social, and cultural rights in the Constitution. Well, there are different types of models in the comparative constitutional law world to incorporate and not to incorporate economic, social, and cultural rights. If you look at American Constitution, it did not have any sort of economic, social, and cultural rights incorporated either in the original one or later by constitutional amendments, 10 famous amendments. It did not incorporate economic, social, and cultural rights. Well, constitutions around the world, in fact, started with recognizing economic, social, and cultural rights. If we look at some oldest constitutions like the Constitution of Finland, Constitution of Mexico, Spain, Russia, Yugoslavia, at the beginning of 19th century, all those constitutions recognized certain principles regarding economic, social, and cultural rights. And none of those constitutional provisions were made judicially unenforceable. Nobody just thought of this particular idea that how could be one part of the supreme law of the land be made judicially unenforceable. We are saying that this is the Constitution, this is the supreme law of the land, and at the same time, one particular part of the constitution will be declared to be judicially unenforceable. This particular model was first developed by Ireland back in 1937. So Ireland actually was the inventor of this particular model of judicial unenforceability of constitutional laws regarding economic, social, and cultural rights. And then what happened? Then it was popularized by Indian constitution, because this is one of the biggest constitutions in the world. And Indian constitution actually popularized this particular idea. And what happened in 1972? We have adopted that particular model. In the name of economic constraints, that we do not have enough economic strength to implement economic, social, and cultural rights right in 1972. So we are not going to recognize all these rights as fundamental rights. And Dr. Ambedkar's vision that was expressed in the Constituent Assembly of India was also affirmed in our constitutional law debate. So what Dr. Ambedkar said in India, that we need to set an economic democracy as the target in front of us to achieve. So the directive principles of state policy, that particular chapter actually from Indian Constitution contains economic, social, and cultural rights. And Dr. Ambedkar said that we really needed to set that as our target to achieve. They were made judicially unenforceable, not justiciable. And that was done purposefully, because of economic constraint. And that economic democracy, in the words of Dr. Ambedkar, was set as the trajectory for Indian nation to achieve, Indian state to achieve, that all economic, social, and cultural rights shall be implemented at some point of time. So we have adopted that particular model fundamentally. One of the members in the Constituent Assembly of Bangladesh, Mr. Surin Gupta, he was a very famous constitutional law expert and a very active member in the Constituent Assembly. Mr. Surin Gupta highly criticized the insertion of economic, social, and cultural rights in the Indian and Irish models. Why? Because he said that we did not achieve our independence to see that these fundamental needs are not recognized by the Constitution as judicially enforceable fundamental rights. He said it. Well, Mr. Tajuddin Ahmed, the first Prime Minister of the interim government in Bangladesh during the time of the Liberation War, he said in the Constituent Assembly debate that if we look at the socialist countries, we will see that they do not depend on the judiciary for implementation of those fundamental rights regarding economic, social, and cultural rights. Rather, they implement these rights through representative government. True, he was right. But if we judge that particular statement in the light of Rosalind Dixon's concept of abusive constitutional borrowing, it was a sort of abusive constitutional borrowing, because socialist countries' constitutions were referred to regarding progressive realization of economic rights. True. But it was not mentioned at the same time that those socialist countries did not declare them to be judicially unenforceable. They were made judicially enforceable, recognizing their progressive nature. So just like South African Constitution, what South African Constitution of 1996 has done regarding judicial enforceability of economic, social, and cultural rights, they have to say that every type of economic burden will be imposed by the judiciary to enforce each and every fundamental need of the people. Rather, that will be progressively realized, of course, depending on the economic strength. Well, if you look at the comments made by Mr. Asaduzzaman in the Constituent Assembly debate, then we see that Chinese constitution, the constitution of Soviet Union and Germany were also referred to. But again, he did not mention about judicial enforceability, justiciability of those constitutional provisions. Well, let me now focus on another thing that regarding Article 47 of our Constitution. It is another very interesting area of the Constitution, both for Bangladesh and India, that can the government, can the parliament make any law violating fundamental rights in order to give effect to any of the directive principles of state policy, or in case of Bangladesh, to give effect to any of the fundamental principles of state policy in Bangladesh. Dr. Kamal Hussain, the chairman of the Constitution Drafting Committee in 1972, said that taking the Indian experience into consideration, that how much difficulties Indian Parliament actually faced in practice while it wanted to make laws violating fundamental rights in order to give effect to certain directive principles of state policy. Mr. Hussain said that we have enacted Article 47 in our Constitution. That Article 47 has provided a blank check in the hands of the Parliament to enact the necessary laws to give effect to the economic goals of the country to achieve, which has been spelled out in the chapter on fundamental principles of state policy. And here, Mr. Khandakar Abdul Hafiz referred to the powers of the British Parliament. The British Parliament has also an enormous power to make the laws. So such granting of special power to the Parliament in Article 47 was not considered to be something something that was given as an excessive power to the Parliament. And as such, he compared Bangladesh Parliament with the Parliament of the United Kingdom. Well, now I'm coming to another important point, that is constitutional model of the protection of civil and political rights, and what particular debate took place in the Constituent Assembly. As I have already said that regarding civil and political rights, Bangladesh adopted a blend model of Indian style and American style. And at the time of the debate in the Constituent Assembly, one particular idea was given by certain members that to recognize civil and political rights from an absolute perspective. They wanted to see those civil and political rights like freedom of speech, expression, press, assembly, association. They wanted to see them without any restriction. And in order to justify, they have referred to certain constitutions. But at the end of the day, they could not justify their point. Rather, the Constitution of Ireland, the Constitution of France, West Germany, Burma, India, United States, all those constitutions were referred to in order to justify the point that those civil and political rights are to be made subject to restrictions. But Mr. Abdulaziz Chaudhry in the Constituent Assembly raised a very important point regarding American Constitution. He said that, look, American Constitution, First Amendment, did not incorporate any restriction or reasonable restriction. It is true that American Supreme Court later developed a set of guidelines regarding imposition of restrictions and reasonable restrictions on different fundamental rights, civil and political rights. But the thing is that the Constitution, First Amendment of American Constitution did not contain any such restriction explicitly. So he argued to go with that American First Amendment right model. But it was finally rejected by the majority in the House. And finally, what we did, that we actually adopted the Indian model of constitutional protection of civil and political rights. There was a debate in the House regarding mentioning the concept of private ownership along with socialism, because we know that socialism was one of the fundamental principles of the constitution and one of the fundamental principles of state policy as well in Bangladesh. So socialism, if that exists in one particular country as a fundamental principle, can private ownership exist at the same time? That was a very big question in our Constituent Assembly debate. And there are certain strong academic debate from socialist perspective on this particular point as well. And it was argued by certain members in the House not to recognize private ownership at all. But finally, majority members have shown that there is no conflict between private ownership and socialism. So in spite of considering socialism as one of the fundamental principles of the Constitution, the concept of private ownership also can be recognized to a limited extent. Of course, not to its fullest extent, as is done in a capitalist state. Rather, that could be accepted to a limited extent. And in order to recognize the concept of private ownership side-by-side socialism in Bangladesh, the Assembly referred to different socialist constitutions, like the Constitution of Germany, Constitution of China, Constitution of the Soviet Union, Czechoslovakia, and have shown that all those constitutions have to some extent recognized the concept of private ownership. Interestingly, the Soviet Constitution of 1917 actually recognized the concept of private ownership only for the purpose of succession, that the property that comes through succession. But our Constitution has in fact adopted it from a broader perspective. So from that particular perspective, one can pose the question that in adopting that private ownership concept, did the debate do constitutional borrowing or abusive constitutional borrowing? Because at the end of the day, that particular principle was made judicially unenforceable, which was non-existent at that time in those socialist constitutions. So from that perspective, that also can be termed perhaps as an abusive constitutional borrowing. Then regarding the concept of acquisition of property and compensation, we have relied on Indian constitutional provision that the government has been empowered to acquire the property, but of course, by giving adequate compensation. And the Constitution of Germany was referred to, and the House said that we are not adopting German model because German model did not grant compensation, whereas Indian model allowed the compensation to be given to the people from whom the property will be acquired. Well, the Constitution of the Soviet Union, Article 111, was referred by the House in order to accept the concept of camera trial in certain cases, and in order to establish the control over the lower judiciary in its Articles 114 and 115. Indian model was accepted. Indian model that was developed in Articles 235 and 237 of the Indian Constitution. That particular model has been accepted in our Constitution's Article 114 and 115. And if we look at the debate, we'll see that there are certain constitutions which were referred in the Constituent Assembly debate, but not to accept something from there, rather to contradict. So referral was made for two different purposes, to accept something and not to accept something. For example, in our debate, the Government of India Act 1935, that particular constitutional document was referred, and it was mentioned in the House that the Act of 1935 did not grant separation of power. So we are not following that particular Act of 1935. Rather, we are following the separation of power model in our Constitution. And again, the Constitution of Pakistan was referred regarding the provision on preventive detention. And we said it in the assembly that look at Pakistani constitution that contained provision regarding preventive detention, and we are not inserting any provision on preventive detention. It is to be mentioned here that we did not mention anything regarding preventive detention because we thought that we became the victims of that preventive detention law during the Pakistani regime. So we did not adopt that particular idea. But later we inserted it in 1973 in our constitution by the Constitution's Second Amendment Act. Well, perhaps now I should refer to some abusive constitutional borrowing, that how did the Constituent Assembly make certain abusive constitutional borrowing or certain borrowing that was not adequately justified. For example, at one point of the debate, Advocate Mir Hossain Chaudhary said that if we consider British Constitution to be the best constitution, then Bangladesh Constitution is also the best one. But I did not get anything that substantiated his comments. That has substantiated his comments. Then Mrs. Badrun Nisa, she said in the assembly that, with reference to a book on parliamentary government in England, she said that British Prime Minister has more power than the German king or American president, so she did not see any problem in granting huge powers to the Prime Minister. Well, there is statement something like this, which can be argued to constitute abusive constitutional borrowing back in 1972. Well, let me now focus on a few other points, and I'm going to conclude my lecture soon, maybe in 10 minutes, because my time is coming to an end. Now, at this stage, I'm going to focus on certain judicial transplants that has been made by Bangladesh judiciary following Indian model. Well, one popular model that has been popular in the entire comparative constitutional law world, that is an Indian model, that is right to life model, protection of rights through the constitutional right to life. This particular right to life model of the protection of constitutional rights was adopted in Bangladesh, was transplanted in Bangladesh back in 1996 in Dr. Mohideen Farooq case. Dr. Mohideen Farooq case explicitly referred to Francis Koralai case of 1981 and Bondhuwa Mukti Morcha versus Union of India case, Olga Tellis case, Benson versus India case, Vikram Dao Singh versus State of Bihar, Subhash Kumar versus State of Bihar. All these cases on the right to life were cited by the Supreme Court of Bangladesh back in 1996 in Dr. Mohideen Farooq case in adopting the right to life model for the protection of those economic, social, and cultural rights which are made judicially unenforceable in the Constitution. Again, in liberalization of locus standi and introducing the concept of public interest litigation, certain judgments pronounced by Indian Supreme Court have been transplanted in our constitutional law system. One such famous case is S.P. Gupta and others versus President of India 1982. That was explicitly mentioned in Mohideen Farooq and other cases. And another such case is People's Union for Democratic Rights versus Union of India, decided in 1982. This particular case, along with the S.P. Gupta case, were referred by our appellate division in Muhammad Tayyib case back in 2011, which was a case of suo motu application for a public interest litigation issue. Although the court said that the idea of suo motu writ, in fact, rooted in Marbury versus Madison case, because no one applied before the court to set aside the Judiciary Act of 1789. But American Supreme Court finally declared the Judiciary Act of 1789 to be null and void. So that was the first example of suo motu application of the jurisdiction of the court. And referring to that particular Marwari versus Medicine, the court then relied on S.P. Gupta and other Indian cases in order to establish the epistolary jurisdiction of the Supreme Court to deal with certain issues suo motu. Well, then there is another idea of sovereignty of parliament, that is the sovereignty of parliament in Bangladesh, does that look like British parliament or Indian parliament? That particular question was asked in Zerai Khan Panna case in 2015. And the court said, parliament in India, unlike in England, is not supreme. Unlike in England. Rather, it is the Constitution of India that is supreme. And Parliament will have to act within the limitations imposed by the Constitution. Then the High Court Division concluded that this particular view of the Indian Supreme Court, in the humble opinion of the High Court Division of the Supreme Court of Bangladesh, clearly holds good in Bangladeshi jurisdiction. Well, I'm focusing on another particular concept of basic structure of the Constitution. We know that this is a famous Indian innovation, basic structure theory, although it is subject to great controversy in comparative constitutional law. So there are many comparative constitutional lawyers and constitutional lawyers of different countries who argue against this particular doctrine of basic structure. However, this particular concept greatly influenced our Supreme Court back in 1989 in Anwar Hussain case, while the Supreme Court of Bangladesh adopted the concept of basic structure, an organic concept of basic structure that the court will develop the idea from time to time. But I'm just giving an update to that particular doctrine of basic structure, that although the basic structure of the Constitution was modeled on Indian model, but later in 2011, Bangladesh, unlike India, has introduced the concept of basic structure explicitly in the Constitution. So now the Constitution of Bangladesh explicitly has mentioned certain basic structure in the Constitution. So this is the latest development of basic structure in Bangladesh. Well, I'm concluding my lecture because the time has ended, I think, with one or 2 points that in case of judicial lawmaking, we know there is a famous case of Vishakha versus state of Rajasthan in India that greatly influenced Bangladeshi Supreme Court to adapt the same guidelines against sexual harassment at workplace in BNWLA case. And regarding the concept of public compensation as a constitutional tort, the cases of Nilavati Behera and Rudul Shah also greatly influenced Bangladeshi Supreme Court in transplanting the idea of constitutional law compensation, public law compensation in the constitutional law jurisprudence of Bangladesh. And there are sometimes we see that an abusive constitutional borrowing, for example, in Kudrat Elahi case in Bangladesh, we see that there was an abusive constitutional borrowing by the Supreme Court. In what sense? That the Constitution of Bangladesh has kept open the option for negative enforcement of fundamental principles of state policy, unlike India, under its Article 72 of the Constitution, that declares that if any law is passed violating any constitutional provision, that will be declared to be null and void. And as such, negative enforcement of economic, social, and cultural rights in Bangladesh is possible. But following the Indian model, the court did not agree with that particular point of view. So in my opinion, that was an abusive constitutional borrowing. So let me conclude my lecture that the constitutional borrowing is generally good, but abusive borrowing must be avoided. And Bangladesh Constitution was influenced by comparative constitutional law materials in 1972. And Indian Constitution also played an influential role at that time on the adoption of the Constitution of Bangladesh. Judicial transplant is also good, so long abusive constitutional borrowing is avoided. There are a lot of judicial transplants in the constitutional law of Bangladesh. Both comparative constitutional law, including Indian constitutional law, have a great influence on those judicial transplants on different constitutional law issues in Bangladesh. And I think that is normal for Bangladesh, because Bangladesh constitutional law jurisdiction is a newcomer on board comparing to Indian constitution or American constitution or British constitutional law. So finally, borrowing and transplants are to be made carefully and effectively with a good intention, only then constitutional law of a country can be enriched. Otherwise, it will go back. It will go back using the same tool. That's all from my side. Thank you so much for inviting me again and for hearing me on this particular constitutional issue of common interest both for Bangladesh and India. Thank you so much.
Thank you, Professor Haque. It was really very engaging. It was having a lot of information on the comparative perspective, and particularly the Constitutional Assembly debate, which you have mentioned here. And it was very interesting that how the Constitutional Assembly members, they had discussed on the different aspects of the Bangladeshi Constitution. So it has invited a lot of questions also, and we will pick few questions because of lack of a little bit time. We are having some restraints of the time. So one question which we are having, that is the from the chat box, that is what is the role of the people of in the constitutional borrowing? How if anything, which is not as per the spirits of the people, if you are borrowing, then how that kind of borrowing can be made as a good kind of a part of the constitution, even though it is a good piece of constitutional borrowing. So how it can be done if the people are not ready to accept that?
Well, this is a very interesting question. Indeed, there is no doubt that if someone may pose this particular question, you are taking something from, like for example, you're taking something from American constitutional jurisdiction. How are you so sure that is supported by the people of India or by the people of Bangladesh? That will remain a question always, all the times, and that's why there are certain theories that justify that particular adoption. A theory like functionalism or a theory like expressivism. Functionalism says that if the constitutional lawyers or the judges, they think that if this particular foreign idea is adopted in my country, that will perform the same function in the same way that is in line with our constitutional goal, then there is no harm. Or it will provide the same result in our jurisdiction as well. For example, let me give an example that the constitutional enforcement of economic, social, and cultural rights through the right to life model. That model has actually been developed by Indian Supreme Court, which has been transplanted in the constitution of Bangladesh. Well, so the people in Bangladesh generally consider that, of course, there is no harm in getting enforcement of economic, social, and cultural rights through the adoption of that particular right to life model. And so long the people will consider that particular model beneficial, only then that will stand in that particular jurisdiction. Otherwise, it will fail. I'm telling you the truth. If something of very weird type is taken from any foreign jurisdiction, then that transplantation will not survive. That will not survive eventually.
The second question is that how the Bangladeshi judiciary defines the compensation, because in India the compensation has been defined as just an equivalent. Whether they are defining as actual or they are taking the same kind of the way of interpretation as we are having in the Indian Constitution. Well,
we are doing the same thing what India has done in Nilabati Behera case. That this is nothing but a consolation, and compensation is something that cannot be awarded for violation of any liberty of the people or for losing any life. The court cannot give any real compensation. So compensation is calculated on certain hypothetical basis as consolation.
Another question is that in India, people are questioning that the Indian Constitution is like a quasi-federal. Some people like K.C. Vere, they are saying that. So how the Bangladeshi Constitution is there, whether they are also having some features of unitary model or federal model, they are having mixed culture. And in what situation it becomes a unitary, like whether they are having a provision like Article 356 or 352 as we are having in the Constitution, they are also having this kind of the provisions?
Well, interesting question. Yes, we have followed Indian Constitution in many respects, but the nature of the state is totally different. We do not have any sort of element of federalism. We are completely unitary state, and that particular concept of unitary state has been established as a basic structure of the Constitution as well, both by the Supreme Court and recently by the explicit constitutional provision regarding basic structure back in 2011 in our Constitution.
Another question is that how do you understand Article 47, which empowers so much in the Bangladeshi Constitution, the Parliament, that they can make the law even if they want to implement any kind of the principles which are there also. So how do you understand that, whether is this kind of a provision where we can say that it becomes so much supreme? However, you had said that the judiciary has said that it's must work. So how do you think that this kind of the provisions are in consonance with the principles of constitutionalism?
Yeah. Yes. Thank you, Professor. This is a very important question from Indian perspective as well. That how much fundamental rights can be curtailed in the name of the implementation of the directive principles of state policy, and it's a matter of big research and controversy as well. My precise opinion regarding this is that just good governance, that will ensure everything. If the government does and believes in good governance, then of course, only reasonable legislation that is required for the implementation of economic policy and that requires the curtailment of fundamental rights to a reasonable extent will be done. If good governance is there, if good governance is not there, then that can be misused. Thank you.
Well, the last question is here, that is with respect to some certain constitution like the German constitution and the Japanese constitution, they have been made by the people who were not the part of that country, like the American came and they made the constitution of Japanese. So what about those kind of the constitution where the transplantation are happening with the people who are not belonging to that nation? So how these countries are surviving, because Japanese constitution is one of the constitution which is still unamended. So how do you understand this kind of a constitution where the people are not participating, but still the transplantation are happening and it is working very well?
In one sentence, perhaps the answer is it depends on the constitutional interpretation, that how do they interpret their constitution?
Okay.
Thank you so much.
So thank you, Professor Haque. It was really very interesting. I hope that the students who are there, the faculties who are there, they have got a lot of information, and it has helped them for a comparative study in the Constitution as well. So thank you, Professor Haque, for being here and delivering a very thoughtful lecture here. Thank you.
And thank you to Honorable Dean as well. Thank you so much. And Nirma is my favorite place because I visited Nirma earlier. And in the last year also I delivered a lecture. I always enjoy to be a part of Nirma University. Thank you so much.
Thanks.